evening. Let me chime in and just introduce Michael. Michael's with the Office of the Chief Financial Officer. So it's part of the umbrella organization that oversees BJA and other grant-making agencies. So Michael's was kind enough to take time out of his busy schedule in this grant season, but always busy, to talk to us about financial management. He's speaking broadly to federal procurement rules, and then at the end, I'll make some remarks, I think, just tying things together, speaking a little more specifically to the body-worn camera program, which has some unique aspects to it. But Michael's the expert on federal procurement processes and the grant financial management training that all our grantees are required to take. So with that, I'll turn it over to Michael.
Welcome, everyone, and thank you, John, for that great introduction. As you say, I'm from the Office of the Chief Financial Officer. I do a lot of training on various types of topics. One of the things we do in OCFO is a 2-day training. Prior to COVID, it was in person. It is our hope to move back to in person come the first of the year. So John was gracious enough to ask me to present this again this year in reference to the body-worn camera grant. So with that, I want to start off, talk about the program requirements applicable to some federal grant programs. And again, not all, but some. So with your particular grant program, there is a matching requirement. The good thing about this particular program is that you can match either way, or both matching requirements are allowed under this particular grant program. There are some grant programs that only allow cash, some allow only in-kind, and some a combination of both, which is the case with this particular grant program. So we understand cash to be what we call hard match, and in-kind to be more of a soft match. But what I want to stress when we're talking about in-kind match is that you understand in-kind match and how to value it, okay? I'll give you an example. I was approached by a grantee that wanted to use, they had the flexibility to use in-kind match. So they approached me and said that, can we use, for example, an officer's salary as our in-kind match? Now, based on how the question was presented, my answer had to be no, okay? Because if we're using an officer's salary, then naturally we're talking about cash match. If the officer, for example, was volunteering their time, not being paid for it, then that would become an in-kind match. The thing to be mindful about that type of scenario that I just used is that the salary or the funds, I don't want to say funds because we're talking about in-kind, but the amount that we're using has to be applicable to the services that's being provided. I'll give you another example. I was approached by a grantee that said that based on their drug court program, the judge that worked this drug court program wanted to provide an additional service of mentoring or for the program. So the individual asked me about using the judge's salary, okay? So based on that, they couldn't use the judge's salary because the judge wasn't performing his regular or routine services of judgeship, but they had to come up or find the pay or the reasonable salary for a mentoring service. So again, the amount that we're going to use as in-kind needs to definitely match the service that's being provided. So how to calculate match? This scenario here provides for an 80-20 match. So I'll give you an idea. It works the same regardless of of the amount of the match, I want to say that your match is straightforward. It's a 50% match. So for every federal dollar, you're matching it with your own dollar. So that's pretty easy. But just to stick with this, to give you an idea of how to calculate match, you always want to start with the amount of the federal award. So once you know the amount of the federal award, to me, it's kind of easy, because now based on the matching requirement or percentage, you're dividing that by the amount of the award. That will produce the adjusted program cost or project cost. So in my example here, I used 80/20. So $80,000 represents the federal share. That could be the body-worn camera amount as well. So if we divide that by the amount of, or the percentage of the federal share that the 80,000 represents, again, in my case, we're talking about an 80/20 matching requirement. So the federal share would be 80%. Divide that would give you the total adjusted project cost of $100,000. So based on the adjusted program project cost, multiply the matching requirement, in my case, 20%, and it gives you the $20,000 that is the required match. So using this for the body-worn camera, let's just say that it's an $80,000 award. It represents 50%. To multiply that would give you 160. The 160 multiplied by 50% would bring you back to the 80,000, or like I said, a dollar for dollar matching requirement. Now let's dive in and start talking about procurement procedures. These are general guidelines based on the federal requirements, but again, based on what we're actually talking about, they can be, again, as a guide for procurement transactions. So when we are actually talking about procurement, there is nothing in the uniform guidance that requires an organization to use the federal procurement guidelines unless they don't have any procurement procedures at all. So it's always encouraged that any state or non-federal entity always follow their own policy and procedures. Again, you've been using these policy and procedures way before the grant program. So again, we're encouraging you to use your own unless they do not provide what we call the most efficient protection for the federal grant program. So again, if you don't have your own procurement procedures, or it is determined that they are more liberal, I want to say, than the federal government, then there is a requirement that we may require you to use the federal procurement guidelines. Documentation is very important, not only for procurement, but for all of the charges that you charge against the grant program. I want to say that any documentation, especially here with procurement, should be sufficient enough to stand on its own. So if we're talking about salaries, time and attendance being properly signed, that information or that documentation should be sufficient enough to stand on its own doing an audit. I shouldn't have to, don't get me wrong, I may have some questions about various things to make sure that they're in line, but I should be able to audit trail, based on an audit trail, follow what was going on in your organization to lead you to this amount and the amount that was charged against the grant. So for example, when I'm talking about procurement, there are certain things that I'm going to be looking for. I'm going to be looking for that purchase order, make sure that it was properly authorized and signed off on, whatever that equipment, body-worn camera, that we identify a vendor, also an invoice to pay for those body-worn cameras, and then also the ultimate payment for those. So again, the official files should set that audit trail where I can visually understand and see what actually happened in reference to the procurement process. And again, remember I said not only procurement, but for everything that you do with federal grant programs, I'm looking for that audit trail. Now, with the uniform guidance, one of the things that the uniform guidance states is that procurement transactions should be performed in a manner that provides what we call full and open competition, okay? That is saying, in other words, that allow the process to do what it was actually designed to do. So when we're talking about procurement, if we are competing and we have a full and open competition where we're allowing multiple vendors to come in and present their proposal on our bid, that is what the market is designed to do, to bring people together and to compete for your service. And it is always known that by doing it this way, we can get what is known as possibly a better product for the procurement that we've placed out there on the street. Always important to make sure that your bidders list is up to date. People that are no longer in the business should be removed from the list. People that have been suspended or debarred from doing business with the federal government, they should be removed. And then as you find new vendors, they should be added. So one of the most important things is to always make sure that your bidders list is up to date. Next here, for advertising, you want to make sure when we're talking about advertising, it is important to, again, get a wide range of advertisement for your proposal that you're putting out there. One of the things that the federal government kind of frowns on is local preferences, okay? Now, again, remember what I said, allow the market to do what it is designed to do when we get the widest range of bidders coming back. Now, in some cases, and I don't want to like misrepresent this, but there are some cases, and I think that there's one more bullet that follows this, is that if a local preference is used, then you want to make sure that you get authorization from the federal government. Now, like I said, I don't want to misrepresent this. What we're saying when we're looking for the widest or the broadest range of advertisement for a particular service or product, keep in mind when I talk about local preferences, and I give you an example, let's just say the island of Guam, okay? In that case, they may be using local preferences because is it beneficial for the grant for them to go outside of the island in order to get that service? So again, in these cases, there may be, like you say, an authorization from the federal government for an organization to use local preferences, as opposed to what the uniform guidance actually encourage us to do, what is full and open competition. And I do have the term here, sole source. Most of us are actually familiar with this term, sole source, but based on the uniform guidance, they are now calling it the non-competitive process. So again, when we're doing sole source or the non-competitive process, it's something that is allowable, not necessarily always encouraged, but it is something that is allowable. But the thing to keep in mind here with that being something that is allowable is that there should be a justifiable reason for using sole source. Within OJP, there is a program office that does sole source based on their equipment. So the program office is the one that's responsible for writing the sole source justification. So when we're talking about using sole source, and again, there's nothing in the uniform guidance that says that an organization can't use sole source. The only federal requirement is for the amount under $250,000, you just want to keep records as to why you went to this particular entity as opposed to any other entity, but non-competitive procurement or sole source should be used when you can determine that this item and or service is only available from one single source. The best way in order to document that or prove that is what type of survey have you performed to determine that, yes, we look high and wide for an organization or multiple organizations, but this is the only one that offers that service. If we're now talking about a true public emergency, what comes to mind is some type of national disaster. Give you an example, Katrina in Louisiana. Based on this national disaster, it's not beneficial or it doesn't provide the immediate service that is needed. So the full open competition that we encourage you to do is something that you wouldn't do in this particular situation. So if we're talking about a true public emergency, then we're going to find any vendor, hopefully there's somebody that's on our list that would fit these qualifications in order to get that service or that product done. And then after that, there is something that says after a competitive solicitation was performed, you determine that the responses that you have are not adequate enough in order to be considered to do this work. So that may lead you back to a sole source. But again, when we're talking about services provided by one entity that's over $250,000, we consider that non-competitive process and or sole source that would need prior approval. I want to stress this because I found this in multiple site visit findings. So if we're talking about an organization that's providing the same service, and I'll give you an example of what I mean. So let's just say that we're talking about a CPA organization that we hired this year to do the audit, okay? And based on our procurement process, this agency is considered sole source, okay? So let's just say that this year that we used this CPA firm, that the audit cost us, let's just say $200,000, okay? So even though it's sole source, it does not exceed the federal threshold of $250,000, so there is no need to get prior approval. However, next year, if we use this same CPA firm for an additional $200,000, it's not a new contract. It's a contract that we've added on to because remember, this CPA firm is now providing the same service for the next year. So we should be adding to that particular contract as opposed to creating new. So these are some of the things that we found doing site visits where an organization, whether it was intentional or accidentally, created separate contracts. And I'll use this term to get out of the sole source requirement. So again, if we're talking about an organization that's providing the same service over multiple years, we should be doing what is considered addendums to those particular contracts as opposed to creating new contracts. So what are some of the things that you want to put in a sole source or a non-competitive justification? This is only a sample outline. You can add more things to this, but I think at a minimum, if you hit these are something that the awarding agency can look at to make a determination as to whether there's enough information in here to approve that sole source or non-competitive procurement that you're getting ready to enter into. So number one, there should be a brief description of the program, whatever it is. Two, you need to explain why it is necessary to go non-competitive and or sole source. Certain factors that can justify that is an organization's knowledge of the program, their expertise of their employees, their responsiveness to get things done, Okay, so here's some of the things that could help for the justification. So with 3, we want to talk about if there was a survey done. Remember, I talked earlier about a survey. So if there was a survey done that justifies or provides the justification as to why we're going sole source, then that's something good. Again, one of the things that you want to also include, if there was no survey done, then explain why there wasn't a survey done, because the awarding agency may want that survey to be performed before they sign off on that. The other thing here for number 4, if you can provide a statement about, based on the entity that I'm using, okay, to now transfer and go to another organization, the level of time or effort that it would take to bring that new organization up to the same level as the prior organization, we're saying that if you can equate that in dollars, then you stand a good chance of that being approved. So again, what is the impact on the program to stop now using this vendor and bring in another vendor and to bring them up to speed? Any other points to sell the case? What in addition that you can explain to the program office as to why we need to use this particular vendor? Some of the things in that declaration should be that it's in the best interest of the awarding agency and also the federal government in order to continue or to go sole source. There should always be a statement in reference to a conflict of interest. You want to stay from anything that gives the appearance of a conflict of interest. One thing to note, and some of the requests that come in for more time on the grant program or a reason to go sole source, is that there is a time constraint. So keep this in mind. If there is a time constraint, make sure that the time constraint was not the grantee or based on your efforts because you waited until the last minute in order to put this solicitation out on the street. So that will not be a reason to go sole source. So here are some contracting do's as well as contracting don'ts. So when we're talking about contracting dues, you always want to compete. To the extent possible, make sure that you're competing because, again, we always say, let the market do what it was actually designed to do. It is believed that you can get a better product by competing and letting the market do what it is designed to do. So prepare an IFP or RFP, an invitation for bid, okay? When I think about an invitation for bid, I already know what it is that I want in either this service or this product. So I'm putting that solicitation out there on the street, and I want bidders to come in and offer their services for that particular contract. One of the most important things that I'm looking at now is price. So technically, if I'm using an invitation for bid, price is the number one factor. So whoever can meet all the specs at the lowest price should be the winner of that particular program. I had one grantee ask me, said that even though this next vendor wasn't the cheapest, they believed it to be a better product, but they couldn't justify as to why they believed it was a better product, okay? Or the request for proposal. I need something, whether it's service or product, but I'm not 100% sure as to what it is or what it should look like. So now I'm putting out a request for proposal. Now I'm looking for vendors to tell me what it is based on my proposal that I put out there, what I actually need in order to get this done. Again, maintain that updated bidders list, conduct interviews, okay? So if I'm doing the request for proposal, I want to look at these, I want to do interviews with these bidders, look at what each one's offering me, and then based on my input now, ask them to come back with their last and final offer on that. Obtain any types of prior approvals that I'm going to need, especially if I'm talking about sole source or non-competitive. If it's over the $250,000, before I enter into that contract, I want to make sure that I get prior approval for that. Make all of the documentations available. And I'm saying that for this reason. Based on a sole source bid that was put in or that was submitted to the awarding agency for approval, we found out that the actual organization created the sole source because based on the specs that was in the proposal, they kind of eliminated all other vendors from this particular process. So that's another reason why that we want to look at the actual specs that were sent out there. And I give you an example of something that actually happened that required us to put some additional language in the procurement chapter in reference to that. Motorola does radios, okay? So they went around to a police organization saying, do you need police radios? Naturally, the response was yes. So they said that we'll write the specs and the application for this particular award, okay? So when the organization put the bid out there on the street, the only vendor that met all of the specs for those particular radios, naturally, was Motorola. So the other thing that we had to put in the financial guide was that if you write the specs, then you can't bid on that particular contract. Contracting dumps, please do not place unreasonable requirements on a vendor to try to eliminate them. No unnecessary experience. So if the service that I need does not require a doctor's degree, then don't require that the entity or that the staff have certain types of credentials. Never engage in non-competitive pricing. I talked about conflict of interest. You want to stay away from conflict of interest. One thing I want to say about conflict of interest is that there may be the appearance of a conflict of interest, but it needs to be noted. And here's what I mean. If, an example that I want to use is, let's just say that the vendor that's bidding for a service product or whatever the case is, my sister-in-law works for that particular organization, okay? So again, based on the appearance, that could be a conflict, but I should not be on the panel to review that bid to make a determination on whether or not that organization get it. So I need to recuse myself from that bidding process. So again, there are some cases where a conflict of interest may appear, but make sure that there are policy and procedures in your organization to remove yourself from that to eliminate any types of appearance. And then again, don't place unreasonable time frames on an organization. Remember the previous slide where I said that the organization waited till the last minute to put the contract out on the street. So now they're going to require the vendor to meet the deadline in something that could be considered an unreasonable time frame. So one of the things that you always want to make sure that you do, and is a requirement under the uniform guidance, is you want to make sure that you never provide federal funds to an organization that is included on the federal procurement and non-procurement programs list. So I'm saying this for procurement and non-procurement because OMB has taken care of both phases of this. So if I'm talking about a vendor or non-procurement sub-recipient, someone that's going to do an aspect of that work, if I'm passing money down to another organization, I need to make sure that they're not on the suspended and the barred list. I can go to SAMS.gov and obtain that information. And as a site visit, I'm going to be looking to make sure that you've done your due diligence to make sure that this organization that you're passing money down to is not on the suspended and debarment list. So you can check that out at SAMS.gov. I want to say that this process is very easy. Okay, I went into sam.gov, I put in my name, nothing came back. And that's what you want. You want to make sure that nothing come back. There's no records in the excluded party list that identifies me. So you want to print that, put it in the official file folder, because one of the things I want to know is, did you check to make sure that this entity is not suspended or debarred? So that list or that printout from the web page saying that, you know, there was no activity noted for this particular organization is something that you want to put in that official file folder. The most important thing that I want to explain about checking this is that I can check it, and I'm required to check it at the beginning of the process for doing a procurement. Based on the nature of the work, okay, that's being done, I am recommending that you check it somewhere else again during that lifespan. And I guess what I'm really talking about is that non-procurement, or if we're talking about subrecipients. But it's important to go back during the life of that contract and check. Why? Because there have been occasions where, based on the initial process, this organization was not in the excluded party list, but they were en route. There were proceedings that were going up against them. So 6 months later, when they showed up, if the organization does not go back in and look during the life of that award, here's what actually happened. When the organization got ready to either get the final product or do a site visit of the organization, that organization was no longer there because they were deemed a risk on the excluded party list, so they had closed up shop. So again, with the body-worn camera, that may not be an issue, but I want you to keep that in mind for all, and I use this term, all other non-procurement programs that may extend for a while. Just as a recommendation, I truly encourage you to go back in throughout that life and double check and make sure that that organization has not been added to the list. All right, so let's talk about some updates for the uniform guidance. And I do want to say updates, and even though they've been in existence for the last 2 years, I still want you to be mindful of these updates. So with the financial changes in the uniform guidance, and that would relate to procurement, is that in 320, what OMB did here was classify the three types of procurement. Now, all of the ones, micro purchase, sole source, non-competitive, all of that stuff was originally in the uniform guidance prior to the update. The only thing OMB did here was, I want to say, formally classify them. So as you can see, there is this informal method. So when we talk about informal method, we're talking about that micro purchase and or small purchase. When we're talking about formal methods, we're talking about the sealed bid and proposals. Remember I talked about the IFP and the RFP? So those are more formal methods. And then the non-competitive method and or sole source. One of the things to keep in mind is that with these changes, the micro purchase was raised from $3,000 to $10,000. Okay, but the uniform guidance does allow some flexibility. They allow a non-federal entity to self-certify if they want their micro purchase to be more than the current threshold of $10,000. So in other words, a non-federal entity can make their micro purchase as high or up to $50,000 without prior approval. The only thing that you have to do is annually self-certify and provide documentation as to why you've increased your micro purchase to something other than the $10,000 threshold. Another thing was domestic preference. This was something that came out during the Obama administration for the Recovery Act. Then it went away. And as you can see here, OMB kind of brought it back. So in 322, they talk about domestic preferences. So in other words, we're saying that non-federal entities, to the extent practical, and I think that's a good way to phrase that, should provide information in their solicitation where, based on the acquisition of goods and service products, to the extent practical again, that they're using products that have been made in the U.S. Additionally, with that requirement, when we're doing subawards, should be passed down, and contracts should be passed down to those vendors. So again, to the extent practical, you want to make sure that they're using products that were produced in the United States. Okay, with that, I'm going to turn it over to John to wrap this up for us.
Thanks, that was great. I think it's useful to our current grantees, and I think many of them are considering applying for other federal grants. So it's a good refresher. We've got lots of agencies, big and small, and so some of them are grant savvy and some are new to the process. So I think the best we can ask for the new agencies to keep in mind the material in the session. But if you have questions, you need to sort that out. It's best to consult with the state policy advisor. That should be your first point of contact. They know the rules, or if there's something vague, they can negotiate, or they can navigate to OCFO and get the answer for you. One of the things that I think we see, and I think a lot of the material you provided, Michael, helps out. When we come across sole source requests, which really are maybe continuations of contracts. The agency already has a body-worn camera vendor. They're in expansion. They're expanding their program, or they may have an in-car dash provider that also provides body-worn cameras. It's usually within their financial best interest to stay with the vendor, because vendors often charge a premium for the data and transferring the data. So we've worked with them before in sort of keeping them in line with the federal guidelines when they want to continue using a product, or when it's to benefit their financial benefit in terms of competition, to stick with what they already have. So I think you gave us a lot of background and guidelines that'll be helpful to the SPAs. I think above all, just remember the SPAs and I are there to help. The TTA providers aren't really involved in this space too much, but certainly the teams that you're working with for your policy process, the policy processing will point you to your correct person. A little correction here: Tamara White and Florence Lawson have states A through G, as we had in the office hours this morning. Tamara is phasing off of BWC, so Flora will be taking her cases, and Gerardo Velasquez, he has the lion's share of our body-worn camera grants. It has been part of the grant program since its inception in 2015. So between the three of them, me and their supervisor, Darius Lacicero, will walk you through the process. And just above all, remember, we're here to help. This is just a little bit of a distinction. We throw a lot of acronyms at you. So Michael is with the Office of Management. I think I'm leaving out a word there, a budget, and they basically provide financial guidance across of all OJP programs, including the other grant-making agencies, the Bureau of Justice Statistics, National Institute of Justice, the Office of Juvenile Justice and Delinquency, and then the SMART program, which is sex abuse management and tracking. So he's got his hands full, and I really appreciate him taking his time for our BWC grantees today. And then, the Bureau of Justice Assistance is where your grant is administrated. There's the programs office, which handled the majority of the administrative and reporting tasks. There's the policy office where I'm at. I work hand in hand with the programs office, but they're your main go-to on these financial and all administrative issues. And as I alluded to, the TCA provider is working with you. One of the policy conditions that has to be met is the establishment of a body-worn camera policy, and they work hand in hand with us on that. So just to sort of sort out the alphabet soup here, that's the purpose of this slide. And here is the breakdown of the states. Generally, it's by state. I think Mississippi, we've got, is split, but I think the one that Tomorrow and Flora have is a 2018 grantee. So you're probably already familiar with these individuals. If you've had issues with your budget or needing to have special conditions cleared, remember that tomorrow we'll be having virtual office hours. We had them this morning from 11 to noon. We had a lot of people attending, I think somewhere in the neighborhood of 80. Yeah, and I think now we want to open it to questions for Michael or for me.
John, I do see a couple of questions in the chat. The first one for you both, are there any restrictions or guidelines regarding purchasing contracts already established, for example, state contracts?
Yeah, I'm going to, based on how the question is that they are piggybacking off of a contract that was already awarded to the state. Sounds like that's what they're talking about. So there is no federal requirement where you can't do that. And if I'm understanding the question correctly, that is encouraged, because that speeds up the process as opposed to going out on solicitation on your own. If the state, for example, has a contract with Ford Company to produce police cars and you piggyback off of that, that is encouraging, if I'm understanding the question correctly.
Yeah, I think that's precisely I can't speak for the person who posted the question, but that seems in line. And what we're seeing, Michael, is we're seeing more states stepping up and providing, either requiring body-worn cameras and now providing funding for body-worn cameras, either through competitive grant programs or reimbursement programs. So some of the states are taking an active role in organizing and requiring body-worn cameras and setting standards, not just for their purchase, but also for their use. So we're seeing more of that, and it's likely to be something in the future. And I think generally the benefit of that is the economy of scale the states are leveraging for the body-worn cameras. And then it's just more efficient, I think, to manage those centrally. There may be 4 or 5 law enforcement agencies or more who are reporting to one prosecutor and sharing the body-worn camera footage, and for them to come from the same vendor in the same proprietary format is often cost-effective sort of throughout the justice system.
Thank you. The next question. We have an upcoming site visit. Could you please review what might be required from a technical standpoint? We understand the financial and administrative parts.
If what is expected on the financial side is to make sure that the accounting systems separately identify those costs by grant programs. That's one of the things that we look for to make sure that funds aren't commingled together. The other things that we're going to be looking for, and we always ask for this up front, is the agency's policy and procedures. How do you operate? Because when we come in and look at your organization, we want to make sure that you are operating according to the policy and procedures. And then after that, it's just a matter of verifying or audit tracking costs that's been charged to the grant. So that's basically what we're looking for financially, to make sure that everything that was charged against the grant is allowable and authorized under the grant program.
I believe that's all of the questions that have come through the chat, John.
Okay, great. Well, again, the SPAs, the state policy advisors, Gerardo, Flora, and for a short time tomorrow will be, are your principal points of contact for those types of questions, and as well as, they sometimes do desk audits or site visits. So, and they're usually pretty good about telling you beforehand what they're expecting if they're arriving to do an on-site visit. They also do some desk audits virtually but they're pretty transparent and upfront with what they want. But they're always available for contact. With that, I think we'll close this session